Chapter 5 deals with conflicts of interest. Our concern with avoiding conflicts of interest affects paralegals just as it affects attorneys. So, this ethical obligation is very similar to confidentiality, that we all are following the same rules and the way these rules apply to us are the exact same way. Now, conflicts of interest this obligation is the flip side of our duty to protect confidentiality. So if you ever are looking at a situation and you're not sure if it's a conflict, start thinking about confidentiality because that may help you resolve the issue a little bit easier. We cannot protect confidentiality if we have a conflict of interest. And we'll look at the definition of conflict of interest in just a second. We need to ensure that we avoid conflicts of interest because that helps us not only ensure to our clients that we are maintaining their confidentiality, but this also demonstrates our loyalty to our client and our objectivity to our client, that we are their advocate and that there are no other factors other than advocating in their best interest to the best of our ability. Now, how do we define conflicts of interest? There's two possible definitions. I think the second one is probably the one that would more likely affect most of us or be the type of conflict that we would see in practice. But the first one is when you have a clash or a conflict between a public role and private interests. So your public role would be you are a paralegal, and your private interest would be something personal, family, other business, that type of thing. The second definition is when one has opposing or competing interests that renders impartiality and confidentiality in either situation difficult or impossible. So that takes the first definition a little bit further because it does include the fact that when you have this type of conflict of interest, you no longer can be impartial. You no longer can ensure confidentiality in either situation. So whether it's two different clients situation or whether it is a client in a personal situation, that you lose the ability to be impartial, you lose the ability to protect confidentiality. Now, one of the best things about being a paralegal dealing with this situation is that you do not have to be the person that ultimately makes the decision whether or not there is a conflict of interest. What you need to be able to do is understand enough about them so you know when to ask an attorney for their decision on whether or not a conflict exists. Now, most conflicts are going to be caught when the new prospective client calls our office. Every firm needs to have a conflict check system, which is just a database of all their clients and all the opposing parties with appropriate identifying information, because you can certainly have multiple people who have the same name, John Smith or Mary Johnson. And so when that happens, we look for middle names, middle initials, addresses, birth dates, those types of things to see if they are in fact the same person. When the new prospective client calls in the office, the person who is talking with them, which is usually going to be the receptionist, they're going to ask for their name and they're going to ask for the name of the opposing party. They're going to put it in the system. If it shows up as a potential conflict, keep in mind, it might not actually be a conflict. And we're going to look at some of those reasons in a little bit. But if it doesn't appear to be a conflict, then the appointment can be scheduled for the new client. They can come in, and if everything goes well, we can end up representing them. If it looks like it's a potential client, that is something that needs to be taken generally to the attorney. And the attorney can look more in depth into it to see if it is in fact a client. So unless you are the person doing that initial telephone conversation with a prospective client, this should all be done by the time you start working on cases. One thing, though, to keep in mind is if you are working on a case and you do discover that there are additional parties to that case, whether there's another client that needs to join the action, or there's an additional opposing party that needs to be joined to the action, new conflict check has to be run. And so the fact that it's done initially does not absolve us from doing it again. Anytime there is a new party, or we learn a party goes by a different name. Anytime that happens, we need to run the conflict check again to ensure that we don't have a conflict. Okay. So the rules dealing with what is called concurrent client conflicts, which is a bit of a mouthful. It's also called simultaneous representation. Very fancy words, but it just means when do we have a conflict between two current clients? When do we have a situation where we cannot represent either or both of those clients? So the first one listed is the easiest one. We can never represent plaintiff and defendant in the same actions. And this is true even if the parties are amicable and agreeable. We cannot represent plaintiff and defendant in the same action. It just does not work. They're adversaries in that action, even if they're agreeable at this moment. They do not have the same interest. They may have the same interest in resolving the case, but they don't have the same interest in what the best resolution may be. They need to have their own attorneys, or they need to be representing themselves. This can be a very tricky situation for attorney. Actually, I take that back. It's not really a tricky situation at all, but what attorneys have to be very clear on, if they're representing a party and the opposing party is unrepresented, the attorney has to be very clear to that opposing party that the attorney is not representing him or her. And we have to be very careful in that situation that we don't say anything to them that sounds like we're giving legal advice. And we've already learned what legal advice is in the UPL chapter. So it makes it very challenging when we are dealing with an unrepresented opposing party, because we do have to make sure we are very clear that our client is our client and that is the only person we are representing. There was a case several years ago of an attorney who eventually was disbarred, but among the many things he did incorrectly is he would represent both plaintiff and defendant in divorce cases. And the part I thought was kind of the most interesting was the fact that in determining who would be the plaintiff in those cases, he would flip a coin. And that's how he would determine who would be plaintiff and who would be defendant. So that was one of the many actions that got him into a lot of trouble. And also interesting, I found, was one of the reasons that he gave for all of his ethical violations was the fact that he was addicted to video games. And so video gaming was taking over his life, and he was not spending time on his cases, even though he was still taking on clients and still acting as if he was their representative. So anyway, if you do have that situation, plaintiff and defendant, even if they agree, attorney cannot represent both of them. So even if both plaintiff and defendant are sitting in attorney's office and saying, we both want you to represent us in this, attorney cannot do them. And if you think about it logically, that's the equivalent of one of those parties consenting to their attorney suing them. And under law, you cannot consent to your own attorney suing you. So it's just never, ever going to be allowed. So that is the most straightforward, easiest one. Now, there can be other situations where it might be a current client conflict, but it's not a plaintiff and defendant situation. So if we look at Rule 1.7, Rules of Professional Conduct, the first part of that rule is what we were just talking about. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client. So obviously you can be no more directly adverse than being plaintiff and defendant in the same case. But you can also have situations where clients' interests may be adverse, but they're not parties to the same case. So my example, which is probably not the best example, but it's the best one that I can come up with. You're representing, or your attorney's representing client A in a zoning matter. Attorney's also representing client B in a completely different matter, has nothing to do with zoning. But if attorney is successful in the zoning case, it may adversely affect the property values of client B. So even though client B is not at this point directly involved in the zoning case, that would be a current client conflict, that by doing something to help client A, I am inadvertently hurting client B. So that is a current client conflict, even though they are not parties to the same case. Okay, so the rule that deals with that is 1.7a. If there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client or some other obligation, that is a concurrent conflict of interest. And that means that the attorney cannot generally take that case, or at least take the second case. If they're already involved in the first case, they can continue representing that client. Now, if there is not a significant risk that the representation of any client will be materially limited, then it's not a conflict and the attorney can represent them. So the fact that the two clients know each other, would have no bearing on the case in the majority of circumstances. So when can an attorney represent clients when there is a concurrent conflict of interest? And the lawyer can only do this if the lawyer reasonably believes that he or she will be able to provide competent and diligent representation to each client, and the representation is not otherwise prohibited by law, and the representation does not involve the assertion of a claim by one client against another client, and each affected client gives informed consent. Okay, so you have this 4-factor test. That is a very high burden for the attorney to meet. And so in the majority of cases, the attorney is not going to be able to do that. And then as a realistic situation, since you have to get clients' informed consent, I would think that's a pretty tricky conversation to have with a client. You have to go to a client and say, I have this conflict of interest. I am allowed under the rules that I can represent both you and this other party. I do not believe this in any way affects my ability to assist you in the case, and I need you to sign this form. The attorney really has to feel comfortable that they're not violating this rule and that they're not going to be limited in the representation of either client. And keep in mind that this would not be allowed in any situation where you're representing plaintiff and defendant in the same case. That's already not allowed by law. So it's going to be in other types of situations, which probably don't occur very often. But in certain areas of law, or if you are working in a smaller community, you may see the situation occur, every once in a while. So what you have to keep in mind is that the presumption is that the simultaneous representation is a conflict. So the burden is always going to be on the attorney to prove that it is not a conflict. When the attorney goes to a client and says, I need you to give informed consent, here's the situation, keep in mind the attorney cannot disclose any confidential information about the other case. So the attorney is even limited in how they explain that conflict. Typically, when we tell a client we have a conflict of interest, that's all we can tell them is that we have a conflict of interest. We cannot give any information about the other case. So it can be very tricky because a lot of times a client would want to know what is the conflict, and they cannot do that. Also, just as a side note, if you are ever the person who is doing the conflict check and going back to the client and telling the client, I'm sorry, we cannot discuss your case with you, we have a conflict of interest, that client frequently will say, what is the conflict? We cannot tell them. We have to say, I'm sorry, due to confidentiality, I cannot disclose that information. Some prospective clients do not take that well. They feel like they are just, they're given a story. You don't want to take their case. They're being blackballed. We're just using fancy words because we don't want to talk to them. All of which is not true at all. We want clients, but we are not able to do that. So if you're ever in that situation where a client's pushing you to find out more information about a conflict, we cannot release any of that information.